I think we'll get started. Good morning or afternoon, and thank you for joining us today. My name is Jennifer Januska, and I'm the Director of Data and Intellectual Property for Protein Industries Canada. We appreciate you taking the time to join us today, wherever in Canada you find yourself. Attendees are muted, and we ask you to use the Q&A function to ask questions. Feel free to pop them into the discussion as we go along with the presentation, but we'll also leave some time at the end. I'd like to start today by noting that Protein Industries Canada acknowledges that our head office, located in Regina, Saskatchewan, is on Treaty 4 territory, the original lands of the Cree, Ojibwe, Saulteaux, Dakota, Nakota, and Lakota, and the homeland of the Meati Nation. Further, we respect and affirm the inherent and treaty rights of all Indigenous peoples across this land. Protein Industries Canada has and will continue to honor the commitments to self-determination and sovereignty we have made to Indigenous nations and peoples. And with that, I'm pleased to introduce our speaker for today, Mr. Dan Natchik. Dan is an IP litigator, trademark agent, and associate at Osler, Hoskin and Harcourt, based in their Ottawa office. He's experienced in providing strategic advice to clients and representing them in patent, trademark, copyright, industrial design, and trade secret disputes. His practice has stretched across a broad base of industries, including agribusiness, consumer products, pharmaceuticals, chemicals, and construction. Prior to becoming a lawyer, Dan was a biochemistry researcher with a particular focus on protein structure and function. The genesis for today's talk was a study done by Dan and his colleagues Nathaniel Lipkiss and Caitlin Margison on patenting activity in the alt meat space. I thought it would be very interesting for our members and friends of PIC to hear more about this, some of the cases that are happening in this area, and for Dan to place it a little more in a strategic context related to patent and trade secret strategy for companies in this space. I think we'll all have a lot to chew on from today's presentation, and so I don't want to take up any more of the available time. I'm going to pass it over to Dan now to begin the presentation.
All right, thank you, Jennifer. Good morning, everyone, or if you happen to be in my time zone, then good afternoon. I'm very happy to be here today, and I hope that you get a lot out of this presentation. Just very quickly following on Jennifer's acknowledgement, I'd like to also acknowledge that I'm speaking to you today from the traditional and unceded territory of the Algonquin Nation. Just to give you a little bit of background, a little bit extra background on me, just before we dig into things, which might give you some context as to why this area matters a lot to me. You know, I was born and raised in Northern Ontario, farming communities surrounding where I grew up. I studied biochemistry, as Jennifer said. I was at the University of Guelph, which you may know is a big time agricultural school. So I got a lot of exposure to agri-tech at that time. There were farmers feed cities signs everywhere in Guelph. And while my focus was on protein science and was research heavy and basic science focused, I have studied protein structure and function at the molecular level, including muscle and plant proteins, which we will be talking about in some more detail today, and in which I'm sure you are all very well aware of. You know, I've worked in my legal career with numerous ag tech and agri-food and food processing clients. So, you know, this is an area that has mattered a lot to me, and something that I hope will continue to be a focus of what I do to try and help companies with their IP rights. So in terms of the goals of this presentation, just to give a very quick overview, I'm hoping that I can pass along a deeper understanding of patents and trade secrets, and a good ability to be able to sort of distinguish between the two, and also to consider your company's approach to the IP that would be covered by a patent or a trade secret, and how to choose between the two, because there are a number of differences in terms of what that actually looks for your company now and down the road and in the future, and what you might want to be doing from a strategy perspective. And then, as Jennifer said, I will be talking about a couple of food protein cases that came out of the United States that were the subject of the article that I wrote with my colleagues here at Osler. So IP strategy at a broad level is important. It's important to think about this strategy from your company's perspective on your own terms. IP is not cheap. It's expensive. The value that you get from it has to outweigh ultimately how much you put into it at the outset, but also factoring any risks and potential successes down the road in terms of enforcing IP rights or defending against IP rights. So strategy can be very important at the outset, but it should be very much customized. If it doesn't facilitate your company's long-term success, then it's a waste of time and money in the end. So just diving into patents now, you may or may not have familiarity with the basics of patent law, but just for the benefit of anyone who doesn't really have that in-depth exposure to patents at this point, patents come in essentially a two-part document. There's the disclosure, which is sort of, the longer worded description of what the invention actually is. And then the claims are these itemized list of the actual subject matter of what is being claimed as the exclusive property under the patent. And in order to get a patent, what you're claiming must be new, useful, and inventive. There are other criteria as well, but those are sort of the big three. And you can obtain a patent after filing a patent application if a regional or national patent office, in Canada that would be the Canadian Intellectual Property Office, agrees that the claims of the patent meet those requirements of new, useful, inventive, and the other requirements that come along with that. What do you get for your patent? You get a 20-year monopoly from the filing date that prevents the unauthorized making, using, or selling of the claimed invention. And that's a long period of time, but you also have to keep in mind that you have to file the patent first and get it issued before you start to be able to enforce that patent against others if anyone seeks to actually infringe on your monopoly that you gain from that patent. So the actual term of the monopoly may be a bit shorter by a couple of years, depends on the subject matter of the patent and what the patent office does with it. The other thing to keep in mind is that once you file a patent, unless you withdraw it within the first 18 months, it will be published at latest within 18 months of the date of the application. So essentially, you are allowing the public to see your invention, and in exchange, you get this long-term monopoly, but it does have an end date after the 20-year period is up. What subject matter can be patented? Well, this is language that comes straight out of the Patent Act, the statute that governs patents in Canada. Any new and useful machine, manufacture, composition of matter, or any new and useful improvement thereof, if that new and useful process is inventive. So Jennifer asked me to confirm in particular, in terms of patenting a recipe, you can definitely patent something that's a recipe or any combination of ingredients that makes up a composition of matter that you see there in the definition. And so as long as it meets the other criteria, that is definitely an area that you can patent in. There are some areas where it's still controversial whether or not you can patent something, and there's a lot of court decisions that sort of come down on these issues. Methods of medical treatment and diagnosis, probably not all that relevant to this group. Higher order life forms are generally determined not to be patentable. There's a Harvard mouse case, and it's about a mouse that has a certain cancer gene in it. It's used for research purposes, and that was found to not be patentable. Anything to do with human beings specifically are not patentable. But importantly, there is a case out of our Supreme Court, Monsanto and Schmeiser, that specifically does not include plants and seeds. So just to be clear, plants and seeds and the genetic makeup of those plants and seeds or anything flowing from them are per se going to be patentable. Single-celled organisms are also patentable. Proteins, genes, generally speaking, are going to be patentable as long as they meet all these other criteria. And then software patents are another category where there is some controversy. In terms of when these inventions are patentable, the controversial ones, if it's not directed to an abstract idea or a natural phenomenon, or amounts to something significantly more than the ineligible concepts that are controversial, then maybe you will get your patent allowed. Or if it's directed to a very specific implementation. So there's a decision to make when someone in your company has come up with an invention, and some questions that you might have to ask yourself. Is it even eligible for a patent? That's generally having to do with what we were just talking about. Can my invention be copied if I release it to the public? So the patent will essentially effectively publish what your invention is once it's published through the patent office after that 18-month period, or earlier if you choose to publish it sooner. But if you're only filing the patent, say in Canada, and someone can reverse engineer it, then there's a possibility that that publication can lead to copying of your invention in another country. A big consideration for most companies is, do I have the money to patent? And that comes down to, balancing what the value of the patent is versus how much it's going to cost to patent it. And finally, are my competitors patenting? If your competitors have a large patent portfolio and you don't, that can impact, investments and your competitors' ability to, block you from the marketplace on certain things. And ultimately, at the end of the day, having your own patent portfolio can help you if you're sued, as there may be an opportunity with the other party to cross-license if you each have patent rights. It can be much more difficult if you're not dealing in patents and you just have a trade secret to actually license that trade secret, because it stops being a trade secret as soon as you tell someone about it. Your patents, if they came first in time, can also be used to invalidate the other side's patents on the basis of novelty or obviousness. Trade secrets can't act as a shield in this way, as they're not published. Other IP rights can sometimes come into play depending on what you're seeking to protect. I've been involved in a significant case involving a food producer relating to an industrial design on the shape of a food product. Copyright can come into play as well, including where software or schematics or operating manuals are involved. Trademarks are a little bit more separate from the innovation side and are focused more on protecting brand identities. But essentially, when you have an invention, you're really thinking about patent versus trade secret. And I've got a pro tip here, loose lips sink ships. So the key there is that if you want to patent something or you want to maintain something as a trade secret, for a trade secret, you essentially need contractual, operational, and physical controls in place to maintain the trade secret. Calling something a trade secret doesn't make it so. And we'll talk a bit about that later. And for patents, before you filed the patent application, you also have to be careful about maintaining that information as confidential. And there are rules in some countries, including Canada, where you may have up to a year in terms of the disclosure of that information before filing the patent application, but that doesn't apply across the board in all countries. So generally speaking, you should be trying to keep things secret until such time as you are actually filing the patent application and crystallizing your patent rights. Or for trade secrets, keeping them secret forever until you no longer need to use them and you're sure of that. So I've already touched on trade secrets a little bit, but as an overview, they actually are quite broad in terms of what they can protect. Anything commercially valuable, as long as you treat it as secret or strictly confidential. There is no term of protection. This is a big advantage over patents. If you can keep it secret indefinitely, then you can keep maintaining that secret, and your competitors won't know how to actually make your product unless it is something that is easy to reverse engineer. Or if someone does independently discover or invent it, this is where a trade secret has a disadvantage. If someone independently discovers or invents it, or in the reverse engineering scenario, is able to reverse engineer it, then you can lose your trade secret because that other person didn't get it by secret means or by breaching your confidentiality. They simply arrived at the same conclusion that you had at an earlier point in time. If you have a patent, on the other hand, you have that protection for the life of your patent, even if someone comes up with it after the fact. For trade secrets, another issue is that they can be a little bit fragile from the perspective of once your secret is out, you can't get it back. That's the opposite of patents. Once your secret's out, you have that exclusivity until your patent term is up. And closer to the end of this presentation, I will go through some common strategies to maintain and protect trade secrets. Generally speaking, there's actually quite a bit of work to do to make sure that your company is in the best position possible to ensure that any trade secrets you're relying on are maintained for the long run. More generally, talking about risks for IP, including patents and trade secrets, there are offensive risks. That's the risk that someone might use your invention without your permission. And there are defensive risks, and that's the risk that you're using someone else's patented invention without their permission, and the risk that you're accused of unauthorized use. And that's the type of risk where you could end up getting drawn into a court battle that you really don't want. So offensive IP risk, probably the most obvious one, if you know about patents, is infringement. So this can arise in a couple of ways. Well, many ways actually, but a couple of examples here. If your employee steals a trade secret that they or others created within your company and then goes and builds their own competing system, that's a risk of you losing that competitive advantage that you get from that trade secret. The more traditional patent infringement is where a third party infringes your patent or trademark or copyright that you own. And the focus here on patents, drilling down on that infringement, if you suspect that a third party is infringing your patent, it's probably a good idea to retain patent litigation counsel as soon as possible. Patent infringement claims can only reach back to obtain monetary awards 6 years from the date that you bring your claim. So that sort of acts like a form of a limitation period that you may have heard about in other areas of law. And litigation counsel will also have to run a conflict check before doing anything. So there may be a few days wait at the outset before you can actually even disclose any of the information about your case to counsel that you've contacted. So there are situations sometimes where you may end up getting referred to another lawyer because those conflict situations can't be resolved with the lawyer that you contacted initially. When you do retain counsel, your counsel may or may not advise sending a demand letter, which is often known as a cease and desist letter. But that's not a mandatory step. And whether you send a letter first and the tone of that letter, or whether you just go ahead and start a lawsuit, will depend a lot on your situation and the nature of the allegedly infringing activities. Litigation is expensive, so it's important to think carefully about your initial approach when you discover someone is infringing. It can significantly impact settlement discussions depending on what the tone of your letter is. And sometimes, in some cases, on the advice of your lawyer, direct business-to-business contact can be effective to reach resolution without escalating the situation. But I would recommend, even in that case, that you seek counsel advice first so you get a full understanding of your rights and your options before forging ahead. And also on that point, any communications without your lawyer present can be cited against you later in any court case that comes up. Whereas if your lawyer is included on the communications, then you may be able to maintain some level of privilege such that they don't end up in front of the court at a later point. And there's sort of a myth in Canada or just amongst a lot of businesses in Canada that Canada is not, the best place to bring a patent infringement action. If you have a patent in the United States, maybe you go there. But Canada is actually quite a popular destination for patent litigation, and clients get a lot out of proceeding in Canada instead of for example, in the US. It's a lot cheaper in Canada. We have a similar but not identical patent regime to the US. But foreign activities can sometimes bleed over into Canada. So, for example, if there's importation or exportation, that may allow you to actually access monetary awards that are greater than just the core of the Canadian business. In Canada, our federal court is very well versed in patent law. That's generally where a lot of proceedings over patents go in Canada. And because the court is so well versed, that can lead to a lot of efficiencies when proceeding. There are no juries, only a judge who decides the case. And that certainly lends itself to more predictable outcomes. Litigation is never predictable, but it's a little bit easier to tell what direction a judge is going to go on a court case as opposed to a jury of 6 members from the general population. And these jury cases are actually quite common in the US in terms of their patent litigation. Our federal court has also become more receptive to early resolution of entire patent cases, or at least major issues in the case, and that can significantly reduce costs by avoiding a trial. So just turning to the bottom of the slide here, another example of offensive IP risk is the failure to capture or maintain your rights. So, for example, if a contractor builds something for your company but never assigns your company the IP, they may take that IP somewhere else and use it for another company, possibly your competitor. You could also have a situation where a commercial partner contracts for access to your IP, and if that contract is not drafted carefully, it may allow them to actually subcontract to your customers and essentially undercut you on something that they now have gained a piece of your exclusive right that you otherwise would have had under your patent. So we've also mentioned defensive patent risk. And this is just an example of defensive patent risk. So BlackBerry, I'm sure you're all aware of, a famous Canadian success story, but now sort of a shadow of its former self, was almost shut down in the U.S. in 2005 because of a patent lawsuit over wireless email patents. So the jury in the U.S. found that these patents were valid and infringed, and there was $53 million in damage, and more importantly to BlackBerry, an injunction preventing them from operating in the U.S. And so BlackBerry ended up paying $612.5 million to settle this lawsuit. And eventually, the US Patent Office re-examined the patents. It's a procedure that's available there. And they were mostly rejected as invalid. And so, BlackBerry ultimately could have gotten out of this injunction eventually, but it had already signed this settlement agreement. And so it was out a whole bunch of money. And while it got around the injunction, it's an issue of things just not working out in terms of timing. So ultimately, the takeaway from this is that while the BlackBerry technology was unquestionably innovative, the company got stuck in this patent thicket, essentially just too many patents that were bogging it down and not allowing it to do what it wanted to, because all these other companies had patents in the same area. And ultimately, this led to the decline in the company. From what it once was, one of the major players, in the cell phone industry and just telecommunications more generally. So where do you go from there in terms of a defensive patent risk? So what we call, this is sort of a jargony term for patent lawyers, but we call it freedom to operate. And that refers to the level of risk of patent infringement that may be associated with making, use, or sale of a particular product or service. So you will have FTO if what you are offering won't infringe the claims of any patent or potentially issuable patent application. And you can obtain freedom to operate as well by avoiding patent claims or by licensing rights to those patents. The other thing that can be a common misconception with freedom to operate is just because you have a patent doesn't mean that you have freedom to operate. You can have a patent on your technology, but there could be another patent out there that is more general or focuses on a piece of what you're using in the patented technology, and that patent is equally valid. It came first, and that can be used against you to enforce the patent against you, and you can either get an injunction against you or have monetary remedies or a combination of both, and that can really throw a wrench in your operations, particularly if that patent is key to your business and you've possibly already earned a lot of money from that patent or have orders from clients, and so it is extremely important to ensure that you have freedom to operate before you actually start proceeding with what you want to do, what is the core of your business operations. I'll just go through this quickly, but this is essentially a guide to what you might need to do to ensure you have freedom to operate. As patent lawyers, we are always happy to provide a comprehensive opinion, but those can be expensive. We can also give limited scope opinions. You're going to find caveats in there, but it is a good way to get a good feel for the marketplace and just the general patents that are surrounding the technology that you're seeking to commercialize. You can also get a preliminary assessment. You're going to get a lot less detail, and therefore there may be some additional risk associated with taking this strategy. Or you know your business well, and if you're comfortable going and searching patent databases, then if you're operating in Canada, then you search the Canadian patent database. If you're operating in other countries, you'll have to search there as well. But because you know your subject matter, you may be able to get some decent information about what is actually out there in terms of patents that you may have to seek to avoid. It doesn't substitute for a comprehensive opinion, but it can certainly be a great first step, so that when you go to talk to patent counsel, you can actually go to them and say, you know, I know that this is out here, but I just need some more background on it, and it can sort of short circuit a lot of the initial work that patent counsel may have to do in sort of just learning the scope of the entire area that you work in. So this is just a big caveat in terms of freedom to operate. You know, there's blind spots, as with any risk assessment. As I mentioned, you have this stealth mode for patents before they're published for up to 18 months. You cannot see those in an FTO assessment. Patent applications can be amended by the entity that's applying for the patent. And so opinions in terms of whether you infringe or not you may have to go back to those and just make sure that none of these patents have actually changed before those patents issue. So, you know, if you find a patent application that seems to be important, then that may be a situation where you need to monitor what's happening at the patent office and make sure that it doesn't pop up later and cause problems for you. Patent claims are also, you know, the patent document is static once the patent issues, but it is possible that the court could come in at a later date and actually enlarge the scope of the patent by doing what we call construing the patent claims. So that's sort of just something that the court does. There's a whole way to do it, and there's expert evidence that goes in, and it's a whole complicated exercise. But really just think about it as, you know, defining certain terms in the patent. Sometimes that's not clear. Sometimes it's very clear what they mean. But just because you think you know what patent claims mean doesn't mean that the court will be of the same opinion. And ultimately, over time, you can manage and minimize these risks. You know, patent applications come out of stealth mode, and patents issue, and they're no longer able to be amended at that point. And, you know, you may get court decisions on patent claims, although that may involve, you know, you getting caught up in the litigation in the first place. But they can be managed and minimized over time, and patent counsel can assist you with that. So this discussion that I'm moving on to here is probably most pertinent to emerging companies, just the way that it's framed. But, you know, if you're not at an emerging company, then these principles can often be easily transferred to more established companies, and you know, where you would still need a regular evaluation of your IP risk exposure for the reasons that I just discussed. So there's sort of, you know, 3 times where you should really be taking stock of your IP risk if you are an emerging company. At conception, you know, making a decision as to whether this is commercially viable given the state of patents and what you can and cannot do. The second time you may want to consider this is at financing. And then the third time is where you're at the cusp of meaningful revenue generation. And, you know, in the interest of time, I'm not going to go into a lot of detail on this, but my slides will be available, just in the interest of getting to some of the nitty-gritty on trade secrets. But, you know, the key takeaway here is that this is something that is really customized to the company itself. And I think developing a business plan and ensuring that you're registering patents in key jurisdictions and doing your freedom to operate searches and IP monitoring and all of that, you know, it costs money, but depending on what your company's view is on all of this, it's something that can really come back later and be something that you're really glad that you did, because it can save a lot of hassles in the long run, especially avoiding something like being sued. Something else that you should keep in mind is ensuring that you can prove that you own your IP. There's something called chain of title. You know, if your employee invents something, do you have an agreement in place to ensure that you can obtain those rights? There's also, you know, confirmatory assignments of IP. These can be done after the fact. Waivers of rights. So there are options if you miss this at the outset. But ultimately, it's very important to ensure that you can prove you own your IP, because if you don't have that chain of title, then really the patent's not going to do anything for you. It'll be in someone else's hands. So the key piece here, and this slide relates to revenue generation for risk assessment, but the key piece here is that every company will have an IP posture, and you may not articulate that in any sort of mission statement or something like that. But once your company is a going concern, or if you are a going concern, it's something worth thinking about what your IP posture is. And so what do I mean by that? So you can see here, this is split into 5 categories. I've seen all of these except passive on the plaintiff side of my litigation practice. Generally, if you're passive towards IP, you're not going to be going out and suing people. But even if your company is passive, you can get caught up defending a dispute. So IP doesn't just go away because you don't want to think about it and you don't think it's important. But any of these other postures are absolutely valid options to take, depending on what your company will actually hope to achieve with the IP at the end of the day. And ultimately, that's something to be balanced, both on a business and a legal side, and in terms of the costs and considerations for your specific business. So at the end of the day, the goal is bespoke IP tailored to your IP posture. So with that, I think it's a good time to move on to talking about the court battles. And I believe Jennifer will be sending around a link to the article that my colleagues and I wrote for my firm's website. So there's some more details and links in there. And if you're interested, I'm always happy to talk about these types of cases because I find them very interesting. So the Impossible Foods in Motif case in the US, Impossible initiated a patent infringement proceeding against Motif. And they claimed that this hamami ingredient, that's a trademark hamami for Motif, infringed Impossible's patent that covered a heme-containing meat replica. So we're talking at this point that this is a non-meat alternative to meat sort of type of burger patty or any other type of they're trying to simulate the texture and the other qualities of beef. Motif countered this by filing a petition to invalidate the patent. And, their claim is essentially that these ingredients have been sold in food products for decades. It may be, if you know anything about heme, it may be no surprise to you that heme is in a lot of both meats and in plants. It's just a naturally occurring molecule in both of these things. So the idea is that it's really the heme-based proteins are what make meat taste like meat, and they can also mimic the reddish pink color of beef. Heme is essentially the central molecule found in the iron-binding red blood cells and they carry oxygen in the blood. So Motif is using one of those proteins, myoglobin, and that's found commonly in muscle tissue, including in cows. Impossible, on the other hand, is using leg hemoglobin, and that also has heme in it, and it originates from the roots of plants like soy. It's not a protein that's produced in animals, but this protein has heme in it, and it's functionally identical to myoglobin. So both of these companies make their proteins in genetically engineered yeast using a fermentation process, and that is also part of the subject of the patent. So what is the patent actually claiming? The invention is sort of the overview piece that you would find in what I described at the beginning as the specification or the description of the patent. But what's actually in the patent claims is what's essentially going to define whether or not someone else is infringing. So essentially, this is a beef replica or muscle replica product with 0.1 to 0.5% of a heme-containing protein. And the patent also claims a fat tissue replica with at least one plant oil and a denatured plant protein. So essentially what they're doing in this patent is saying that you have this heme-containing protein in sort of the muscle tissue replica, and then you add this fat tissue replica and you mix them together in the right way, and you get the physical organization of meat. Think about, you know, marbling that you would see in a nice steak. Motif is saying this isn't new. This is obvious. You know, someone who knows how to do this would know that this is something that could be easily done by someone who knows this area. And you know, there's previous disclosures, what we would call prior art, and they relate to making soy-based proteins that can be incorporated in meat-free products. And there's other disclosures out there that can come in and just demonstrate, you know, that this isn't new and that this is something that would be obvious for anyone to try. So this is an ongoing proceeding. And just to give you an outlook on this, these heme proceedings are still going through the motions of litigation. This could take several years, which in the United States especially is going to be, can be quite expensive. Given that expense, settlement is often one of the most likely outcomes from a litigation matter. Typically, settlement will lead to some sort of licensing fee being paid to the patent owner, so the patent owner gets what they want. And on the other side, the license goes to the person who was sued, so they have certainty that they won't get sued over that patent again. Sometimes the settlements can go outside the scope of just the patent. There can be business aspects that go into the settlement as well. And some cases, the parties are possibly have an aggressive posture towards IP, or possibly they feel like they have a really strong case and aren't getting the resolution that they want from the settlement offers that are on the table. So that might be a case where you actually have one of these going to trial and you are essentially waiting on hearing from the court in terms of what your outcome will be. And that, as I said, can take a few years. You get a decision from the court. They tell you whether your patent is valid. They tell you whether it's infringed. And then possibly there's appeals for another number of years. So that's why settlement is so popular. But as I said, this really depends on your IP posture. You know, if exclusivity is the most important thing to Impossible, they don't want anyone else on the market, they may have to fight. Motif is probably in too deep on this. If they've built their business on these leg hemoglobin products, they may either need a license or they will have to pursue invalidation of the patent or demonstrating that they're not infringing. It is worth noting for this case that there is a corresponding Canadian patent and many other patents and applications of varying subject matter in the food protein space.
Can I interrupt you for a moment? We have a question from
Absolutely.
the audience. What's the main driver for patent litigation costs?
So there are two main drivers, I would say. Your patent litigation counsel, that's a key cost. There are two stages in the litigation where things start to actually get more expensive. That is at discoveries, which is where you go and you get to ask all of these questions of the representative of the other side. And they get to do the same with you. And the defendant will also typically get to ask questions of any inventors on the patent. And so that can take a lot of time. It can be days of discovery. In the US, there is much less of a cap on discovery. So it can take, weeks to get the discovery done. And so you have all these lawyers in the room for weeks, and it depends on how you staff the file, and you can be leaner or you can be more aggressive in terms of how many lawyers you have working on this stuff. And generally speaking, you can get what you pay for, but there's also sort of ways around that, and it depends on the relationship that you have with your patent counsel. And then there's trial, which comes later on, and that's typically after a few years of the proceeding. And of course, that's another situation where there's a lot of work to do to actually try a case, to get all the evidence in, to put your arguments before the court, to make sure that all your legal arguments are in order. So that can be quite expensive as well. So those are legal fees. In Canada, parties can be entitled to costs, partial costs, if they are successful. Those are typically being awarded more and more as lump sum costs. So you can recover quite a bit of your legal fees. In some cases, like 25 is probably on the lower end now, and then I've seen up to 50%. If the other side is being really egregious in terms of the arguments that they're advancing and they're not really worth anything, then you may get more. The other side to that, the whole costs going into litigation, is expert witnesses. So it depends on the area that you're dealing with, but expert witnesses are key to the whole construing the patent and actually teaching the court about the technology and all of that. And so experts charge for their time, and it can take time to actually find the right expert to prove your case. So that's something certainly where it can cost you a lot of money. But that's also something that depends on your IP posture and how much you want to put into it. So that's generally where all that comes from. You can recover typically most of your expert fees if you win a case, because those are what are called disbursements. And so those aren't dealt with typically as much as a percentage. Rather, you get all of your reasonable disbursements. So as long as your expert isn't being, allowed to bill at will, and kind of has some expectations as to what you expect of them and the efficiencies that they should have in terms of preparing their reports, then you can often get most, if not all, of your expert fees back if you win the case. So hopefully that's, I think that's a fairly comprehensive answer to that question, but I think in terms of the actual dollar value, that's something that would have to go into an estimate, and often can vary significantly depending on the subject matter of the patent and the field of the invention that you're dealing with. So I think ultimately the takeaway here is, if heme is truly special in this context, the outcome will be important to the US market, and there may be litigation imminent in Canada and other markets. There are other alternatives that have been tried out there. We came across in our background research for our article, other things that are added to these impossible or beyond meat or any of those types of products that could be out there to add the sizzle or the sort of bleed color that you see in traditional meat. Like beet juice, pomegranate fruit powder, coconut oil, really anything that is a food product that can accomplish that goal. There may be other innovative products out there, but as long as there's a market for this type of thing, there's going to continue to be innovation. And for those truly new and not obvious products, there would be protections required for those, like patents and trade secrets. So I'm not going to go into a ton of detail on this case, but it's about trade secrets. So once I'm done talking about this, I'm going to jump right into our trade secret checklist, because I think it's important to at least quickly go through that before we close things out today. So this is Better Meat and Meati. This is another US case. It's also ongoing. It's also in the fairly early stages. They're essentially using mycelium or mushroom root. It's this thread-like fungus. You can imagine, you know, because of the threads, there can be a lot of cross-linking between them. So it's kind of sticky, it binds together, and it's something that's already known. And you know, it appears in this food product tempeh. So I have a picture of that here, so you can kind of get an idea of what it looks like. If you've never heard of or seen tempeh before, it's not something that I was all that aware of, but it may be something that you're certainly aware of in your industry. And you know, it has soybeans in there, the fungus grows on it, and then it binds together into this sort of one solid piece. And so that's a known food product. But there are many strains of mycelium, and in this case, both companies have elected to keep their specific strains as trade secrets rather than patenting. So Better has a US patent to produce mycelium-based, and it's in quotes here, meat products, because it's not actually meat. And then Meati, on the other hand, has alleged trade secret misappropriation and unfair competition against Better, because they're saying that their former employees stole their confidential information into their innovative textured mycelium design and the process used to create it, and use that information to create a competing product at Better. So the claim is that that stolen information is what went into Better's patent. And then for Better's part, again, they are suing Meati for tortious interference. And that's essentially legal speak for alleging that Meati's claims are false and misrepresent its case to the shareholders and the public. So essentially that their whole trade secret misappropriation case is just designed to publicly shame Better. So without actually commenting on the validity of any of these claims, there's a lot going on here, and it shows that even if you're not dealing in the patent space, or if there is a patent but it's only sort of tangentially involved, there's still a lot to consider here in terms of a risk surrounding trade secrets. These types of cases can often get messy. Employment lawyers can get involved where there's a former employee involved. Articles that have been published about the case are suggestive that that might be the case here. Because there are multiple proceedings and accusations, that can sometimes make settlement more difficult. It's never impossible, but certainly there's a lot of stuff flying around, and sometimes multiple lawyers get involved in cases where there are different subject matters. Like I mentioned, employment law can get involved here. At the end of the day,
sorry, can I interrupt for another question here?
Mm-hmm. Sure.
Just because we're running low on time, I want to make sure that that we address what our listeners are particularly worried about or interested in. Mm-hmm. What is the rationale for litigating in Canada if you hold patents issued in other jurisdictions? Are you obliged then to litigate in all the other jurisdictions as well?
Yes and no. So you can only litigate a Canadian patent in Canada. So that may be a partial answer to the question. If you have a patent in the US, that only covers the US. Although I mentioned that sometimes things can bleed over into Canada in terms of monetary remedies. So even if you have a Canadian and a US patent, it may be desirable to come to Canada first because it's cheaper. The other side to that, and this is sort of the aspect of the no side of the question, is that you know, litigating in one country can actually lead to settlement agreements in multiple countries. Patent Counsel will go in and look for patents in other jurisdictions, and they'll look for cases that are happening in other jurisdictions, just to see what the whole landscape is. So you kind of have to weigh things. Like if the US market is your key market, that may be the place to go. If Canada is important to you, this may be the place to at least start. And if you get things moving in Canada first, you may be able to get to settlement faster, and spend less money doing it, and then start your US litigation maybe a little bit later, or you may not need the US litigation at all. So that's sort of where that comes from in terms of where to go in terms of jurisdiction. It again is going to be very fact specific depending on your company's situation and what your patent portfolio looks like, and where your key markets are, and essentially how much you're willing to spend on this. You know, like if you have a very aggressive stance, then you may just litigate everywhere all at once. And in some cases, you might get actually a different outcome in different places. So, so it's worth considering how the law actually shakes out for you as well. Another important thing in Canada is that the federal court covers the entire country. So if you get a ruling in our federal court, it applies everywhere, whereas in the US, you'll actually start in one of the 9 districts, and you'll have to move up the ladder ultimately to get to the Court of Appeal to have that ruling a little bit more broadly applicable, and to not be a little bit too much into the weeds with the law, but sometimes you can, in the US, you can get different outcomes in different circuits of the US federal court system. So so that's another aspect of it, and there's a lot of strategy that goes into these types of calls. So yeah, hopefully that answers your question. Just to close out this piece, and I promise I will get to the trade secret audit checklist, but essentially, how does this apply to the Canadian market? And this sort of ties to the last question, but innovations can arise at any point in the product cycle. I have a list of points here in terms of processes, machines, compositions, uses that may be applicable to your industry, but they can be something that's outside of this space too. It really is about innovations and inventions. That's where your patents come into play. All of these may be opportunities to gain exclusivity if the finances make sense, or you could consider the long-term benefits of trade secret protection, balancing the risks of exposure there if someone else ends up holding those rights. So I'm not going to go through letter by letter of this trade secret audit checklist, just looking at the time, but I do want you to be aware of it. My colleague here at Osler, Nathaniel Lipkiss, who is a co-author on the article that we wrote, he's a partner in our IP group, and he created this helpful checklist relating to helping companies ensure they're doing what they can to protect their trade secrets. The checklist itself, it's sort of just one page front and back. It's a little bit more compact than it appears on my slides, but I think it's a useful exercise, even if your company has a good trade secret strategy, to determine if there's any blind spots that can reduce future risk of a loss of your company's trade secrets. So this slide is really just about evaluating whether you have trade secrets. But I'd like to sort of focus on, you do an inventory, you perform reviews. The key points here are that you want to get everything down on paper. You want to get agreements in place with employees, in particular, anyone who will be having their hands on the trade secrets. You want to have records of where your trade secrets are stored. You want to make sure you have backup copies, and make sure everything is password protected. You want to be very careful about sharing trade secrets with third parties. Make sure that there are security measures in place. Make sure that there are non-disclosure agreements in place where necessary, and ensure that there's no mistaken sharing with third parties outside the scope of these types of agreements, because that can cause you to lose your trade secret rights outright. Employees should be educated on these things. Orientation is important on that front, making sure that there's full understanding of the importance of these trade secrets to your company and the employees' responsibilities under the policies and any agreements that they've signed, and any updates to changes in these policies. Employee agreements are the typical way to get these in in terms of what an employee will actually agree to. So confidentiality, non-compete agreements, both important, ensuring that the employee fully understands what they're signing on to. And records of who is creating things, not using a third party's information. This is sort of the defensive risk, freedom to operate, ensuring employees aren't just going out and finding someone's patent and just doing and reverse engineering it. That can expose you to patent risk. And ensuring that if your employee is developing something, that there's something to substantiate their claim to ownership, records that are being kept, information of the company that's being used when developing these trade secrets, and any existing IP of the company that's being used as sort of the basis for developing further innovations. And then in terms of misappropriation, you have to determine policies as to how to deal with employees, and any steps that may be in place to respond to perceived misappropriation or threatened misappropriation. You generally want to get on top of these things very quickly before any exposure is more widespread, because it can ultimately lead to a more widespread exposure of the trade secret and make it much harder to put the genie back in the bottle, so to speak. So with that, I think I'm a little bit over time, but we started a little bit later, and so I'm available to answer any more questions that have come up throughout the presentation. As I said, our trade secret checklist is available, so please feel free to contact me if you'd like a copy of that, because I know I did go through it quite quickly. Always seems to sort of happen at the end of the presentation, but in any event, I hope that you got a lot out of this today.
Dan, I want to thank you for what's been a really informative and comprehensive walk through patent and trade secret strategy today. And I know that that my head is spinning, but you've provided a great overview here, and I know that we'll make these slides available to the folks on the call today, and the recording of today's session will also be available. In addition, I've included the link in the chat to the original article, and which included a study of patenting activity in this sector, and appreciate your offer to act as a resource for our members and friends. Thank you all for your time today, and thank you, Dan.
Thank you.